Hi, good afternoon, everybody. My name is Ross Pitkoff, and I'm here with my partner, Sarah Barrickman. We are from the Pitkoff Law Group, which is a commercial litigation and corporate boutique located in the heart of New York City. We have offices in New York, New Jersey, and in the state of Florida, and our practice areas vary, but they primarily deal with all aspects of business litigation as well as corporate drafting. And within the real estate realm, we specifically deal with real estate litigation, partitions, easements, and encroachments, and also deal with the drafting on the commercial side of leases, etc. So just a little bit about us. I started this firm in 2018. The Pitkoff Law Group has grown from a solo practitioner firm to a team of 15. And once again, we service the New York City area with all types of complex disputes. And I wanted to give a brief opportunity to my partner, Sarah Barrickman, to introduce herself.
Hi, good afternoon, everyone. My name is Sarah Barrickman, and I am a partner here at Pickhoff Law Group. I'm actually located in Florida. I have a background in employment litigation defense and commercial litigation. So I like to bring that aspect to our practice, and I look forward to sharing a few hours with you today.
So today we'll start with a brief introduction of the topics that we intend to cover. This is not going to be a full exhaustive exercise concerning every component and aspect of real estate law. However, we are going to do our best to focus on the topic at hand, which is discussing operating agreements, protective measures that one can place in operating agreements, specifically dealing with real estate transactions. So throughout the tenure of today, we will start with what is an LLC, and why is it the preferred mechanism for real estate oriented limited liability companies. We'll discuss why choosing the right entity is important. We'll consider who really is eligible to have an LLC when dealing with real estate and real property. We'll then move on to discuss whether or not it makes sense to have a manager managed LLC or a member managed LLC. Sarah will then be moving on to discuss key provisions that should be included in LLC operating agreements. We'll discuss the best ways to include dispute resolution clauses in these agreements. Then we'll move on to how to shield personal assets from liability. And we'll also discuss how operating agreements impact real estate LLCs in New York. Now, while I just read out that list, I should say that we will not be discussing it in this exact order. Nevertheless, I will now move on to our first substantive slide. So, why do real estate LLCs matter? Well, there's a few primary topics that we always want to consider when discussing LLCs for the purpose of real estate. Number one is liability protection. Number two is tax flexibility, which we will discuss. And number three is operational simplicity. Specifically, with respect to liability protection, LLCs are very valuable because they shield individual members of an LLC from personal liability related to the property's debts, obligations, and lawsuits. So picture the example where partners decide to not have an entity or a company protecting them, and they go into business and decide that they're going to purchase a property, maybe it's a mixed use building, and they will then collect rents and have tenants and go about the process of doing what ultimately individuals managing a property will do. Well, if there's an injury that takes place on the property and a lawsuit's initiated, even if it's the tenant is sued as well, and technically the tenant's supposed to have liability insurance that should cover the landlord, as an unincorporated landlord, the individual owners run the risk of being sued individually. So what does that mean? That means their personal assets, such as their homes, their bank accounts, and any assets that they own are ultimately at risk. So one potential and huge, wonderful aspect of the LLC structure is that it serves as liability protection for the members that own the company. Now, I should say that this limitation is not exhaustive. For example, if a member is an owner of a property and they have an LLC to shield them from liability, if they're engaging in fraudulent acts, perhaps they're taking the deposits of all the tenants in the building and commingling funds, these are types of conduct that would be considered to be beyond the protections afforded by the LLC Act. So ultimately, the courts would pierce the corporate veil and potentially hold a bad faith actor individually liable. So while limited liability protection is afforded by registering an LLC, it is not conclusive. Number two, tax flexibility. Now, this is very important because of the structured entities that you can actually utilize in the state of New York. There is the option of an LLC, a limited liability company, which is subject to the New York Limited Liability Company law. And there are corporations, which is subject to the Business Corporation law. A little bit of history on the Business Corporation law. The corporation is a much older and far more antiquated entity than the LLC. So the corporation, while it has a lot of benefits, has a number of detriments as well. So through the tax lens, when you register an LLC and you now have members or the owners of an LLC under that LLC, when you file taxes, you can file as an S Corp or as a C Corp. Now, when you file as an S Corp, that means that you're essentially, LLCs are being taxed as a pass-through entity, meaning that profits and losses are reported directly on the members' tax returns, which ultimately avoids double taxation. When you're dealing with the C Corp, ultimately the shareholders get taxed twice, once via the corporation and once as shareholders individually. Now, this doesn't mean that there might be times where the LLC doesn't want to elect to be taxed as a C Corp. The LLC can do that. So you get this great flexibility with respect to an LLC as to how you want to file taxes, which makes a big difference, especially when you're dealing with depreciation, cost segregation, and 1031 exchanges, some of which will be discussed in a limited capacity later on. I should mention before we talk tax any further, it will come up throughout the totality of this lecture, but just so we're fully clear, while we are involved in real estate and corporate transactional work as well as litigation, we are not tax strategists, we are not CPAs, and we are not tax attorneys. So generally speaking, though, the benefit of the LLC is that you can avoid the double taxation and that you also have the option to file as a C Corp if it makes sense in the right scenario. The third benefit, the operational simplicity, the functionality and the flexibility of the LLC is pretty extensive. So the LLC offers a flexible management structure. So the LLC is much easier to manage than a corporation. And that's because corporations require owners to issue stock. They require assignment of corporate officers. There's a requirement that annual board meetings are held. And this is all required in order to maintain corporate integrity, meaning if the individual owners of the company want to shield themselves from the liability that we mentioned earlier, they need to show that they heeded to all of these corporate responsibilities. If they don't, even if they didn't act in bad faith, individual liability could be held. Now let's move over to the LLC structure. In an LLC, we circumvent that. So now you don't have to worry about losing the shield of liability simply because you didn't hold an annual board meeting. The LLC structure essentially is created through operating agreements that we're going to talk about in length today. And the benefit of it is that you can create within the parameters of the law a lot of flexible means of how you want the company to operate. So this could be very well used in, for example, a family-owned real estate LLC, where the members can designate one person to manage the day-to-day affairs of the LLC and not have to essentially jump through all the loopholes that would otherwise be required in the corporate structure. So, why an LLC is often preferred? Well, we certainly discussed the benefits of the asset protection of that shield of limited liability. We talked about the pass-through taxation, which is the S Corp election that you do in tax season. And then there's privacy and anonymity. Now, unlike an individual that owns a property, when they register that property and the deed is filed, that's going to be registered in their individual name. When you have an LLC, unless the LLC's ultimate name includes the name of the individual owner or owners of the LLC, there's going to be a level of anonymity where the public is not going to know who the owners of the LLCs are. This is often valuable in real estate investment scenarios where a lot of very well-off individuals or individuals with notoriety or that are very involved in the business and financial sector don't want to disclose that they're actually owning a project or have an ownership interest in a project. And just a little side note here, one question that we often get has to do with the Corporate Transparency Act and how that potentially could impact the anonymity of beneficial owners of companies. So aside from the fact that the CTA has now been delayed and continues to be delayed as of March 2025, the reality is that even if beneficial owners of limited liability companies are forced to register with FinCEN, that information is not publicly available. And that's a common misconception that we often hear. So that information, the beneficial owners of corporations or limited liability companies, is specifically supposed to be used for law enforcement, for governmental bodies, and for intelligence agencies that require information to deal with certain bad faith actors. So generally speaking, the CTA is not something that one needs to be overly concerned about when hoping to maintain anonymity in a general sense with respect to LLCs. Determining whether an LLC is right for your clients. So the general response as to whether or not an LLC is going to be right is going to be that it is. The LLC structure, again, is so beneficial to owners of real estate because of the fact that there is so much capability to render and determine how it is that the company is going to be governed. And we're going to get into the details of many clauses and provisions that we believe are beneficial when preparing operating agreements in the real estate realm. So generally speaking, some things that we'll always want to be mindful of, if you have investors that want to own multiple properties, you're likely going to want to have a new LLC for each separate property. That way you can limit potential liabilities, cash flow can be divided up amongst the different entity bank accounts, and there's clear P&Ls and balance sheets that are aligned with each individual property to guide and figure out how good each property is performing, what the rent rolls are like, what's going on with the tenancies, if all contracts and agreements and leases are up to date, and if there are separate trust accounts and escrow accounts for deposits. Another thing you'll want to be very mindful of, which we're going to talk about in a moment, is whether to have a member managed LLC or a manager managed LLC. And when we then get further into the idea of owning multiple properties, it's often very beneficial to have a holding entity at the top that's owned by the individual members, and then that holding entity will have ownership over all the sub-entities underneath it, and each sub-entity will be the owner of a specific property. That is a fantastic way to shield liability and to ensure that everything is structured in a cohesive way where the properties and everything that takes place, maintenance, capital investments, are all divided up. Now, another benefit of the LLC structure, when companies or when individuals take ownership and landlords take ownership of real property in New York individually, and they wish to transfer their ownership, one thing that needs to be done is that they need to now have a deed. A new deed is going to need to be recorded. A new deed will be signed off. The seller will essentially take ownership of the property. The deed gets recorded. Transfer taxes are paid. Recording fees are paid. And there's a whole financial onslaught that comes along with that process. The benefit of the LLC structure is that you can have an assignment of an interest of a member's rights in a company. And so long as that assignment is less than 50% of the ultimate structure of the LLC, so less than 50% of the LLC, no transfer taxes need to be paid, and beyond that, you're not going to see a new deed being recorded. So avoiding the recording of a new deed every time there's a transfer of ownership is a tremendous plus that the LLC structure provides. But if there is a beneficial ownership change that's above that 50% threshold, then transfer taxes, both city and state, usually 1.425% in the city and 0.4% for the state, will ultimately apply. Okay, moving on, choosing the right entity. Real estate LLCs can mitigate partition actions through strategic drafting. It's important to include waiver language that restricts partition rights and to establish buyout mechanisms to prevent forced sales. So, what is a partition action? In order to have a viable conversation concerning partitions, we should probably start there. A partition action is a legal proceeding that's used to force the division or sale of jointly owned real property when co-owners can't agree on the management or disposition of the property itself. Now, we tend to see these disputes with respect to inherited properties, investment properties, ex-partners especially that own property together, or family members, sometimes brothers and sisters, that have property ownership together, and the relationship has just soured so much over time that one party seeks to partition action in court. Now, a partition action is governed by Article 9 of the Real Property Actions and Proceedings Law, known as the RPAPL. And what essentially happens is that a court will order that the property be sold at auction by private sale, with proceeds distributed based on each party's ownership interest. Without an LLC structure, and when let's say you have two owners of a property that are seeking partition, co-owners do have an absolute right to partition the property, absent a written agreement restricting that right. A referee then tends to take over the process to determine ownership shares, evaluate contributions, and oversee the sale process. Now, this may not sound like a big deal, but this can be a devastating scenario to face, especially when you're the individual owner who doesn't want to see the property sold. Maybe you're the one involved in management and you have the other member of the partner who's not doing anything, and you happen to own the property with joint tenancy or tenants in common. But the bottom line is that the other owner is doing nothing. You're involved with the management. You're involved with the day-to-day. You're doing the maintenance and the repairs and the tenant rolls, etc. So this can be a very disturbing scenario for somebody that doesn't wish to lose a property. How do we correct this? Enter the LLC operating agreement, the LLC structure, and means of avoiding partitions. Now, number one is that in an operating agreement, if you have members of the LLC that now own the property, let's say it's Bob and Ann, they own the property together. Bob and Ann, as members of that LLC, can agree to waive the rights to a partition action altogether in exchange for agreed upon exit mechanisms. So what does that mean? Well, there's some ways that we can work to establish or lay a foundation and a forward-looking means of the parties to part ways if it ever becomes necessary. It's always best to do this before there's a dispute, and it's much better to find a means of solving disputes amicably through the operating agreements process than it is to go into court, to have public filings, which often get very messy, which often become very expensive, and which lead to a lot of resentment, anger, and unfortunately, a lot of legal fees tend to get oriented with that as well. So in the operating agreement structure, we can carve out mechanisms to ensure that we never have to get to that point in time where we're actually running into court. And if we can't guarantee it, we can at least make it far less likely. So here are some ideas and some items that we put into our operating agreements that we find can be of assistance. Number one, there can be a mandatory buyout provision. So in the operating agreement, you can establish clear procedures for how to handle disputes or even forced sales. So for example, with the mandatory buyout clause, you can have a right of first refusal. What would that mean? Well, let's take the scenario of Ann and Bob. Let's say that Ann's become so disgruntled because she believes Bob is not holding up his part of doing what he's supposed to be, and she ultimately wants to sell her interest. Well, Ann can go to a third party, find a bona fide party for value, which would be subject to either a rightly done valuation of the company's assets and an appraisal of the property that's reasonable. And once she gets that purchase price, that offer to buy, she can then, or she would be required under the operating agreement to present that offer to Bob. Bob would then have a limited period of time, let's say 30 days, to decide if he wishes to buy that Ann's ownership interest at the fair market value price that was just given to Ann by that bona fide third-party buyer. If Bob agrees to Ann's offer, then Bob will buy out Ann, and Bob ultimately will be the sole single member owner of that LLC, and thus that LLC is now a single member LLC owning the property at question. And if Bob owned less than 50%, or excuse me, if Ann owned less than 50%, only 48%, let's say, then we can avoid transfer taxes as well in the process. However, if Bob decides, after reviewing the offer presented by Ann, that he's not interested in spending the funds or resources to acquire Ann's interest, Ann could then sell to that bona fide third party, who would then come in as an owner of the LLC, and that new owner would also need to sign an amended operating agreement to ensure that that new owner will adhere to all the terms and conditions of the operating agreement and any potential amendments that would come when this new owner comes into play. So the right of first refusal is always a very important element of any operating agreement when dealing with forced sales or one party's desire to proceed with the sale. Now, sometimes we have other situations. We have disputes where each party is essentially, they're not getting along. And it's not so much about them necessarily wanting to sell. You might have one party that actually wants to buy and they simply want the other partner out, but they don't know if they can do this or they can force this. So what is the answer and how do they go about this? You can have a deadlock clause, which is very similar to a dispute resolution deadlock clause, where one party names their price to another. So in our sample, in this instance, Ann names her price to Bob and says, this is the price that I want you to buy me out at. Now, Ann will then be able to showcase this to Bob. Bob will have 30 days to either decide to agree to buy out Ann, or in the alternative, Bob can say, I'm not going to do that, but you are now forced to buy me out at the price that you set. So the deadlock clause, or implementing this clause, essentially guarantees that when the partners are really not doing well and where there's this irreconcilable difference and breakdown of the business relationship, one party can essentially force a buyout of the other. With respect to these forced sale provisions, they certainly can be daunting. They do come with an inherent level of risk because the party that initiates the process is not going to know whether they're going to be the sole owner, if it's a two-member LLC to keep things simple, or if they are going to actually be bought out and lose their interest altogether. So either way, the individual that initiates this process needs to be prepared for change. Now, it's very important to outline when and how property can be sold. We can also discuss other provisions with respect to forced sales or just sales in general. Let's say that you have a multi-member LLC. It's manager managed, so you have a third-party management company. But what happens when the majority of the members want to sell? Should it just be subject to a 51% ownership? Well, what if you have one member that owns 51% and then a subsequent other members who own 49%, except there are several of them? So an example here, something you can do to protect the rights of the minority owners to ensure that a sale doesn't happen without significant consent, is to create a supermajority clause for substantial and material changes to the LLC. Selling the property that the LLC owns would be considered substantial and material. And in such an instance, you could have a supermajority of votes required in order to force a sale. A supermajority essentially is something above a majority. It's something that can be negotiated into an operating agreement. It could be 2/3. It could be more than 2/3, 75%. Usually not so much more than that, but that's generally what can happen. And then you can have additional means of forcing sales of properties, such as sale triggers based on timeframes, based on occupancy levels, or based on financial performance. Now, obviously, the latter of what I just mentioned might not make so much sense in a very small family-owned 2 or 3 member LLC, but it certainly could make sense when you have multiple investors and many passive investors who want to ensure that there's an adequate means of recovering their capital contributions, but also allows them to know that they're in a position where when certain key performance indicators or certain thresholds are met, they can now force a sale. So choosing the right entity for real estate, this is something that we've really touched upon already, but we discussed the sole proprietorship and the detriments of that because you do not get the limited liability protection, the shield of the corporate veil. That's something we always want. And we have the LLC highlighted in white because it ultimately tends to be the direction that members or individuals that own real estate wish to head in. The only time a corporation will be the desired route is in bigger processes. So if a company is considering IPOing, if you're getting to that point in size where the double taxation is no longer a detriment, but from a tax strategy perspective, it's actually an advantage. So these are things to look out for, but for the purposes of our conversation today, we are going to stay within the realm of the LLC operating agreements. Okay. Member-managed LLCs versus manager-managed LLCs. So a lot of times we get these questions when we set up operating agreements for our clients, and they'll ask us specific questions. We often get questions about member-managed LLCs versus manager-managed LLCs and which makes sense. Also, there's a question of what really is the difference. And for those of you that are familiar with operating agreements, you can often will see on those signatory lines, are we manager managed or are we member managed? So the easiest way to think about this is that a member managed LLC is really ideal for smaller LLCs, less owners, maybe more family oriented, maybe just a mixed use building or a residential building where you have a few tenants and you're collecting rent. Why is that? Because in a member managed LLC, the owners tend to want to have an active involvement in property management. And that includes day-to-day decision-making about leasing, repairs, or tenant matters. So again, this is typical when the LLC is small with a limited number of members. The owners tend to have equal skills and experience in property management or in real estate investing, and the property is usually a single-family rental or a small multi-unit building. The members tend to be family members or close partners who prefer a collaborative approach, and for that reason, they're generally going to want to be involved in the day-to-day. So an example would be a True Person LLC that jointly owns a brownstone in Brooklyn for short-term rentals. They may actually benefit from a member-managed structure since both owners are actively handling bookings, maintenance, and tenant relationships. So very important to keep in mind when you think of small, when you think of the members being involved, maybe it's 2 individuals that own the building. They might have even lived in the building. Oftentimes you'll think of brownstones where the owners live on one of the floors and they're renting the other floors out to the tenants. That tends to be a member managed. The tenants will walk down to the owner's unit if they have an issue, member managed, they're involved in the day-to-day. Now, when to choose a manager managed LLC? So the manager managed LLC is generally ideal in different scenarios. That's when the LLC has passive investors who want limited involvement, when the property is large scale or commercial, which requires professional management expertise via a property management company. The ownership group in these scenarios tends to include many members, often investors, making centralized decision-making essential. The LLC will pursue multiple properties, and members may want to limit involvement to investment decisions rather than operational matters. So an example there is really a manager-managed LLC would be ideal for a multifamily apartment building in Manhattan with several passive investors who prefer a professional manager to handle leasing, maintenance, and compliance. So think of commercial buildings, think of larger buildings in the city where you have a multitude of tenants, where you have commercial tenants, where you're dealing with significant retail. You're not going to have the individual members walking around the building, knocking on doors, requesting rent. You are going to enter into a management agreement. The LLC will enter into a management agreement with a management company, and the management company will then participate in ensuring that rents are being collected, that leases are being signed, that payments are being made, that deposits are being held in escrow in a separate interest-bearing escrow account as is required under the RPAPL. These are very important things, and a manager can actually be a member. So while we're generally talking about outsourced management companies, it is possible for one of the members of an LLC, whether that member is an entity of its own or an individual, to ultimately be the managing member or to ultimately be the manager of the company. So members, of course, who are the owners, owe a fiduciary duty to the LLC, but so do managers. And so management does owe a fiduciary duty, so therefore there is a heightened responsibility to the LLC itself. So drafting considerations when dealing with manager authority versus member voting rights. So generally speaking, if you're going to have a member managed LLC, it needs to be defined specifically what each member will do. And so if the members are going to be involved, if one member is going to be involved with, for example, collecting of rent and ensuring rent rolls make sense, that should ideally be itemized and outlined in the operating agreement. And a specific title can be also offered to that member. If the other member is going to be controlling the bank accounts and first overseeing the financials and the P&Ls and the capital investments and things that need to be done for the upkeep of the building, that should also be outlined. So that way, if there ever were to be a dispute, there is no confusion about the roles of the different members in the company. And with respect to manager-managed entities, just because you may have a management agreement, it's very important to ensure what the overall capacity and role of a managing individual or entity would be. That way, the members can call a meeting of the members if they feel that management is not abiding to what they're supposed to in the operating agreement. Now, of course, you should always have a provision to ensure that any managing member or outside management company is subject to termination if they do things such as, for example, violate fiduciary duties, clearly engage in fraudulent or bad faith conduct, or do anything that arises to conduct that is either illicit or would have a significant material and detrimental impact on the LLC itself. Similarly speaking, it's very important then to have these ejectment protocols in place, what to do if it's believed that a managing member, for example, is violating their fiduciary duties, if there is a process in place for their removal, and how to go about it. So moving along. Key provisions to include and why they matter. So this portion is really devoted to all the different provisions that we want to see in an operating agreement. Of course, we're going to apply them to the real estate industry generally. But nevertheless, let's start going through items one by one. So what do you want to see in an operating agreement? This is an example where you now have a client comes to you and they'd like you to draft an operating agreement, and perhaps they have questions about what we want to see in those agreements. And you now are in a position to guide them and explain to them why it is certain provisions should be present. So, ownership percentages and voting rights. No matter what the size of the LLC is, you're always going to want to have a capitalization table that appears at the end of the operating agreement. That capitalization table will specifically outline every single individual owner of the LLC It will also discuss the percentage of ownership that they have. It usually will include their address for contact purposes. And beyond that, it can also discuss if they made a capital contribution, which we'll discuss a little bit later on. So very important that ownership percentages are always there, because if there ever is a dispute, or if there's a sale, or if there are distributions that are required to, let's say, take place on a quarterly basis pursuant to the operating agreements, the percentage of distribution is going to be tied to the percentage of ownership of each individual member of the LLC. So while some might not think it's so important to specifically see the exact amount of equity ownership that they have on that actual operating agreement, it is essential for the protection of rights. It also bleeds into voting rights. It bleeds into profit distributions, and it will bleed into any equity one can obtain or proceeds one can obtain from a sale if the sale of the property in question ever actually takes place. Once again, responsibilities of members and managers. This we discussed briefly with respect to management of the company, but also members generally. What are their obligations? Are there requirements that we want to mirror shareholder agreements or bylaws where we ultimately have requirements that there are annual meetings? What is required to take a material action? Is it a majority vote of the members? Is it a supermajority vote of the members? What do we want to have tiered voting rights? This can get more and more complex, or it could remain very simple, but nevertheless, unpacking the rights, the roles, and the responsibilities of the members and management is essential in any operating agreement. Then we have profit distribution and capital contributions. Well, we discussed the cap table and capital contributions briefly. So capital contributions, of course, are a means whereby real estate investors are put in a position where they can invest in the LLC as the vehicle for the real estate acquisition, maintenance, or upkeep, and therefore their equity tends to be tied to their investments. Now, we're always going to want to see in that cap table if they made a capital contribution and how much. And why is that? Well, any member that invests in a company that has an attorney is likely going to be told that it's recommended that before profit distributions are made to all of the members, a capital contribution should first be paid back to the member that made that capital contribution in the first place. Now, that doesn't mean that that's always the case. And it doesn't mean that in every operating agreement it's feasible that every member is going to receive a return of their capital contribution before profit distributions start. However, these are things that you want to strongly consider when entering into an operating agreement, because take the difference between one member, keep it simple, two-member LLC. One member is simply operating on sweat equity. The other member made a significant investment, whether it's a couple of $1 million, a couple $100,000, whatever that may be. And now the investor that put the proceeds in, if they don't have a clause that states that they're entitled to a return before distributions are made, they could wind up in a scenario where they're not getting paid back in terms of that capital contribution. They and their partner are taking equal amounts on a quarterly basis, but their capital contribution remains due and outstanding. Always best practice to at least make the effort in the attempt to first get that capital contribution paid back to you, and then have profit distributions proceed from there. Then there's procedures for selling or transferring ownership. So this is also very important, and we touched upon this a little bit earlier. Having rights of first refusal in place when one member wants to sell to a third party, ensuring that there are specific provisions that are adhered to, making sure that there are proper appraisals of the property before any bona fide offer for purchase is made, and then ensuring that there's an adequate amount of time for the non-selling party to have an opportunity to determine if they too want to purchase equity before it's transferred to a third party. Now, you can have a lot of additional provisions. Another benefit of the LLC structure is what happens when it comes to gifts, testamentary gifts, what happens when it comes to having trusts, or ensuring that an individual's entity or equity structure in an LLC, that equity can be transferred upon death through a trust to a loved one, versus simply going through intestate, going through the will process, or just automatically transferring to the other owner of the property. So whenever you have an operating agreement, these are important things to consider. It's not simply about the day-to-day management. It's about long-term voting rights, long-term financial rights, and also that equity ownership. What do we want to do with that equity in the future? If we want it to cede to a family member, that's something that can be placed in an operating agreement as well, with specific triggers required before that transfer can take place. Okay, next we have drafting of dispute resolution provisions. Now, dispute resolution provisions are essential in operating agreements, and there's many means by which we can go about piecing them together. A little bit earlier, we talked about a potential means of what to do when there's a deadlock. Now, a deadlock tends to work when you have two members of an LLC who are 50% owners. So that's the scenario where we had Ann and Bob, where the partners' relationship is essentially breaking down. And in order to avoid an attempted partition, if it's even allowed, unless the LLC precludes it, or in order to avoid a petition for dissolution, which essentially in many ways turns out to be the same thing, there is a mandatory provision where one party can dictate to the other, either I'm going to buy you out at a specified price, you have 30 days to allow me to buy you out, but if you decide to buy me out, then I have to give up my ownership to you. So a deadlock clause can be very valuable in resolving disputes, especially when there's this true deadlock. What else can be done? We can create scenarios where you have a third party mediator selected that's going to oversee a potential resolution. And by the way, I don't mean a mediator with respect to mediation. That's separate. I'm talking about a third party, whether that's a consultant, a fractional advisor, an attorney, just not the attorney, not the company attorney, but a third party that's trusted by the members to ultimately make a decision when the parties are deadlocked and can't seem to move on. This is a very cost-effective means of avoiding a litigation or an arbitration to resolve a dispute because the parties can't reach a decision. And ultimately, it should allow the business to continue to function without there being this complete breakdown of the business relationship. Now, let's assume that either we don't have those provisions or what else happens when there's a dispute. So there are a number of different resolution methods that are available to put into operating agreements. Number one is mandatory mediation, which we'll get into. Number two is arbitration. And number three is litigation. Now, you can also have very interesting clauses drafted where the parties are first required to try and resolve their dispute amicably by mediation. And thereafter, if mediation doesn't work, the parties then proceed to arbitration or litigation. So before we move on from this, let's kind of go into each of these and break them down a little bit more. So with respect to mediation, mediation is a non-binding form of dispute resolution. And generally what happens is in mediation is the parties agree upon a mediator, and this can take place through an entity like JAMS, it could take place through the AAA, the American Arbitration Association, so some sort of alternative dispute resolution body where the parties select a mediator. Each party involved in the dispute will then provide a brief description and a presentation to the mediator before a mediation date is scheduled, showing what the issue is, what the ultimate outcome is that they'd like to see, and providing recommendations for the way that a resolution can take place. These all get submitted to the mediator, and then we have a day of mediation. Now, the mediator will work with all the disgruntled parties to try and reach a resolution. The benefit of mediation is that if it works to resolve the case, you're not going into court. There's no public filing. You're not paying extensive fees for a 1 to 3 year litigation where the parties are spending and spending and spending. And ultimately, if it works, you're able to reach a swift and quick resolution, and the parties can move onward from there. The detriment of mediation is that it's not binding. So no matter what, the mediator can only make recommendations, and if the parties don't agree to it, they cannot be bound to it and cannot be held responsible to agree to whatever it is that the mediator recommends. So if mediation ultimately doesn't work, then the only means of resolving the dispute is going to be through the litigation or arbitration process. Now, there is one other consideration to make via mediation. And by the way, mediation can be used to resolve deadlocks. It can be used when one party wants a buyout. It can be used to decide how to interpret or construe the operating agreement if there's not already a settled third party that's included in the operating agreement to make those types of calls. So there's a lot of advantages. But mediation does have its limitations as well. And the big basic one is that it's not binding. Still, many practitioners do feel that mediation has its benefits, specifically because even if the mediator can't ultimately bind the parties, it does give the parties a sense of how a judge or an arbitrator might rule, because the mediator, who's presumably very experienced in the field, is likely going to make a recommendation that is aligned, for the most part, with what an arbitrator or a jury or a judge ultimately may determine. Now, moving on from there, other methods of resolution are arbitration and litigation. Generally speaking, there's benefits and detriments to both. So The benefits of arbitration is that it is a binding process. You generally have either one arbitrator or a panel of three. It will be brought before an arbitral alternative body dispute resolution body, such as the AAA, such as JAMS. And in those settings, you will have the parties will set forth their claims. A statement of claim is filed by the claimants. You'll then have the respondent providing a response. And then there is a procedural process that's followed that's very similar to the court system, but the rules are a little bit more laxed. Ultimately, arbitration is much more efficient in that it's faster than litigation. You can actually get to have an arbitration hearing within 6 months, or certainly even within a year, to ultimately reach a determination, and it's a binding decision. So that's the benefit of arbitration. The benefits actually include the fact that it's private, the fact that you can reach an outcome with relative quickness and ease, and of course that you don't have to deal with the idea of the publicity of an actual litigation being started. So that's why arbitration tends to be favored. The detriments, though, similarly, are that it's expensive. The parties will pay for the arbitrator's fees, especially if you have a panel of three. Then you can imagine you have attorney's fees that are being paid, you have the arbitrator's fees that are being paid, and you cannot appeal a decision that's made by an arbitrator unless their decision is so egregious that it's thought that there's some sort of bad faith or malfeasance involved with that decision. So while arbitration has its benefits, mainly the ability to expeditiously reach a conclusion, the costs, the fees, and the lack of an appeal of an ultimate determination render it also a kind of quid pro quo when you're considering if that's the best avenue or if litigation ultimately is the best avenue. Now, let's talk about litigation. And this is important, by the way, when you're drafting your operating agreements. If you're somebody that's very worried about your public reputation, and maybe you're not so worried about the financial costs, you're probably going to want to see an arbitration clause. If, on the other hand, you are very averse to having to expend resources on an arbitrator and you don't mind the idea of a public filing, then maybe litigation is the better route. So with respect to litigation, litigation is done in a public forum. Now, a lot of these disputes we're talking about would likely be filed in state court, filed in Supreme Court in the county in which the property is located. But, certain scenarios you could have a federal filing as well. These filings ultimately will be public. They are of public record, meaning that they can be located, easily sought out. If there is ever a background search reported, they are likely to come up. However, you're not paying arbitrators' fees. And typically speaking, and perhaps it's to the benefit or detriment, but litigation isn't resolved in 1 year. The litigation process can be timely. It can be far more costly in one sense that it can travel on for years and years, so you don't get a swift and speedy and expedited resolution. So people sometimes don't mind litigation because they don't mind that they don't have to pay the extra arbitration costs. They don't mind that it could take longer than arbitration, and they don't mind that it's public. If that's the case, then public litigation is probably the way that you'll want to go. And if that's the case, you'll want to ensure that there's mandatory and binding language in the operating agreement concerning litigation. Now, another point that I'd like to make. A lot of times you'll see clauses in these operating agreements that say that the parties consent to arbitration. You need to be very mindful of the difference between mandatory and permissive language in dispute resolution clauses. We've seen cases where the proper language is not included, so that when parties thought that they were subject to binding arbitration, guess what? They actually wound up in the court process, and even if they moved to compel arbitration to just get it out of court, get it out of the public filing, the courts ultimately determined that the nature and construct of the provision was considered permissive, meaning that the parties had the option to go to arbitration, but were not necessarily required to. So strong language such as shall, the parties herein shall submit their disputes to binding arbitration with the AAA, with JAMS. That's the type of language you're going to want to see, because absent the strength of that language, you could wind up in a scenario where you think that you have an arbitration provision, or you even think you have mandatory attempts at mediation prior to litigation, but guess what? It was actually optional and wasn't actually mandatory. So these are little drafting tips to be mindful of when you're piecing together, hopefully very, very clear, concise, and enforceable clauses in operating agreements. Okay, and now getting to the latter half of our presentation for my portion, we are going to be discussing drafting capital distribution provisions and what they ultimately should look like. So, focusing on capital distribution provisions in LLC operating agreements for real estate. And we discussed capital contributions briefly, but we're going to go into a little bit more detail here. So for initial contributions, you always want to define the timing and the valuation of those contributions. And when I say initial contribution, I'm talking about an initial investment by a member into an LLC for the purpose of making an investment for a real estate project, whether that's to acquire, whether that's to provide capital, etc. So, number one, be very mindful and be very clear and direct about timing. It's essential that you specify when the initial capital contributions are due. Is it upon signing the operating agreement, or is it tied to specific project milestones? Number two, what's the valuation of that contribution? You're going to want to clarify how contributions are valued, particularly for non-cash assets like property, services, or intellectual property. As an example, if one member contributes land while another provides cash, how is the land's value to be determined? Is there an independent appraisal? Is it just an agreement made by the members? It's very important that we truly consider the scope of valuations and contributions, because we know that contributions can be simple sweat equity and they simply can be cash, but it can also be other considerations such as assets, which also provide a certain value to the business. Now, once we've figured out the timing and we've properly attributed a valuation, it's necessary to document this. It needs to be emphasized in the operating agreement that these contributions are made in writing and that there's full transparency on the value, so that way you avoid future disputes. Number two, future capital needs. So what about capital calls? Now, for those of you unfamiliar, capital call procedures are procedures that are in some operating agreements, though not all, that basically will have certain trigger events that say, in the event of XYZ, then the members of the company will be called upon to make a capital contribution. So in other words, if, for example, there is a deficit, then there might be a mandatory capital call, or the managing member has the option to make a capital call, where all the members need to top up and provide a specific amount of capital to the business. When you have something like this in place, it is essential that this is very, very, very clearly outlined. Because I can tell you, we are a litigation firm, and we have seen many scenarios where the triggering events for capital calls are so convoluted and confusing that certain members will put in the capital call, certain will say that we were never required to, and certain will just outright refuse. And then there's this question of what happens to everybody's equity. So you'll always want to be sure that whenever triggering events are going to happen, they need to be defined. So you want to define when an additional capital call is going to be required. Is it when a budget overruns? Is it when there are unexpected repairs? And if so, what is that monetary threshold to reach? Or is it when you're having cash flow issues? And again, how do we define a cash flow issue? What level of cash flow is it? Is it tied to net profits? Is it tied to gross profits? There's so many ways and means by which you can set up these triggering events. Again, it could also be at the discretion of a managing member. If that managing member is a majority owner, it's happened, but probably not the best scenario, because it does create a lot of animosity and sets forth the foundation for potential objections based upon self-interest of the managing member. Nevertheless, triggering events need to be clearly delineated, thought out, and written out in a very neat and cohesive operating agreement. What else? Notice provisions. Specify the time frame that members have to respond to a capital call. So in other words, let's say the managing member decides they're putting out a capital call. How much time do the members have to put in the funds? If you leave it, make it, let's say 3 days or 3 business days, not every member may have access to capital right away. They may need to draw down on a loan of their own. They may need to liquidate some stock. We don't know what everybody's position is. So the good faith means of doing this is to ensure that there's an adequate amount of time for the members to not only adhere to the capital call, but also balance it out with the idea that the company may need funds right away. So while we want to give a fair amount of time for the member to obtain the capital and put it into the company, there also needs to be this balance that there might be some urgency by one of the members. Of course, you can also have additional provisions, such as the managing member or others may have a right to issue a loan to the company in emergency situations, which it's agreed will be paid back prior to any other distributions being paid to other members. Or you could have somebody make an additional investment and their equity can change. There's no shortage of means by which you can set these things up. It's just imperative that these things are thought out, discussed in depth, and contemplated by the members of the company, so that way there's no confusion when something does come up that requires us to look at those triggering events in the operating agreements. And then, of course, there's consequences for non-payment of capital contributions. So what happens if a member simply fails to meet their obligation? Now, sometimes it's a case where a member simply chooses not to because they really don't care. Other times the member is lacking capital and they're just not in a position where they can make the capital contribution. So in these instances, when you're dealing with these scenarios, dilution is often a scenario that will be a consequence. So in other words, if one member is unable to make their capital contribution, their equity ownership in the LLC might be diluted. And then, of course, there's the question of by how much will it be diluted? There can also be consequences that are greater and more forceful than dilution. It could just be dilution to the proportionate share that they don't put in, but you can also have a mandatory sale, a forced sale clause, where if one member fails to make a capital contribution, they then are required to sell their capital interest to the other members or the LLC at an agreed upon fair market value, which would be determined by an appraisal or evaluation made by the company's valuator or a non-partial valuator. So always very important when considering capital contributions and capital calls, how we're going to construct all of this, because as you can see, it could have very significant consequences for the members involved. Moving on from there, profit and loss allocation. So profit and loss allocation can get very tricky. We can deal with proportional to ownership versus special allocations. So basically, profit and loss allocation needs to be defined. How are we defining gross profits? How are we defining net profits? When are we splitting, providing distributions based upon profit and loss allocation? Is it tied to net profits? What's it ultimately going to be tied to? And how do we see a return on our investment? Then there's ongoing contributions. So what does that look like? Maintenance and operating costs. We're always going to want to clarify how recurring expenses are going to be funded. Do members pay quarterly into a reserve fund, or are there periodic contributions? Do we simply make capital calls when the business is in a state of disrepair, or when we're reaching a scenario where tenants aren't paying their rent and suddenly our expenses are exceeding our funding? Or do we require that each month that the members make an additional contribution, which, by the way, can come out of a proportion of their distribution, but maybe it doesn't? So these are things that we want to be mindful of, how to ensure that there's capitalization of the company. And then, of course, there's reinvestment of profits. We can specify whether profits can be reinvested automatically or if the members must ultimately agree to such a scenario. And just speaking a little bit further, I see we have non-contribution consequences. When a member fails to meet their financial obligations, it needs to be abundantly clear what the consequences are. I cannot stress this enough. So if it's dilution of ownership, often you'll see a non-contributing member's ownership percentage decrease while the contributing members' shares increase. So if, for example, a 25% member fails to contribute to a capital call, the remaining members may absorb that ownership interest proportionally. In the forced sale scenario, you always want to consider whether non-contributing members should be required to sell their interest at a discounted value or at fair market value. And then potentially we can have just a loss of voting rights. Non-payment can result in a suspension of decision-making authority to incentivize compliance. So now we've just run through a number of these different scenarios, all of which are very meritorious and all of which need to be considered when piecing together your ultimate operating agreement. Now, moving on, other considerations when you're dealing with the operating agreements, we've already touched upon taxes, we touched upon maintenance and repairs. Taxes will be discussed further in part 2 of this lecture. Certainly insurance premiums, these are things that we're going to want to be mindful of. They need to be spelled out in the operating agreement. So any material expenses of the business, of the LLC, for the purpose of managing and maintaining that property, those should be outlined in your operating agreement. It's very important that you do so. Let's see. Then we come back to dispute resolution provisions. Here we have just a conversation concerning dispute resolution clauses and things that can lead to disputes. Certainly when you have capital contributions that are made that are uneven, but they're not aligned with equity valuations, that tends to be an area where we see disputes because of this lack of clarity. Also, when it comes down to refinancing or sales of the property, having the proper mechanisms planned in advance. What constitutes a material alteration in the business, such as, for example, selling the property or even a refinance? Do we need a supermajority to decide that, or is that simply done by a majority vote of the members? These types of things need to be written out. These types of things need to be oriented properly. And if you don't have them, you're going to have problems with your operating agreement, because at some point, when there's no clarity, it tends to lead to disputes. And we've talked about most of the other dispute resolution points. One other point that's very important is indemnification. That's something that we don't have in the slides, but which it's important to touch upon really briefly. But ultimately, when you're dealing with operating agreements and you're dealing with especially member managed or manager managed companies, those members that are involved in management, we're going to want to ensure that there's indemnification by the company for them in the event that there's litigation that targets not only the LLC, but individual members. So if an individual member is sued for one reason or another, so long as their conduct is not done in bad faith, it's not intentional, it's not reckless or egregious, the LLC itself should have an indemnification provision in the operating agreement that agrees that the company will provide a defense and then indemnify and hold harmless the members of the LLC who had nothing to do with any wrongdoing. Now, if there's a scenario where a member of an LLC ultimately was involved with wrongdoing and ultimately wasn't just negligent, but perhaps was grossly negligent, or was reckless, or worse, involved him or herself in detrimental conduct, committed fraudulent conduct, converted resources or assets, took off with company funds, then of course, if that individual and the LLC are involved in any sort of lawsuit or litigation, indemnification should not apply. So ensuring that an indemnification clause includes all of the descriptions of when coverage will be provided versus when there's a full disclaimer is essential in any operating agreement, because if that language isn't there, then you can enter into scenarios where individual members may get sued, and even though they were expecting that limited liability company protection, they do have it with respect to the LLC being sued. But the bottom line is, if they're named individually, even if they can get the case dismissed because they had nothing to do with it, you're still involved in the litigation, you're still paying attorney's fees. And the unfortunate reality is sometimes innocent members of companies will simply settle cases and provide monetary compensation. So that's ultimately the totality and the scale of the operating agreement conversation that I'm going to be having with you this morning, or I should say this afternoon. My partner, Sarah Barrickman, will be continuing for the next hour.
Hi, good afternoon again. This is Sarah Barrickman. And just to reintroduce myself, I am in Florida, but I'm licensed and so happy and honored to serve clients both in Florida and New York. I'm licensed in both jurisdictions. And it was very interesting to me to hear Ross's first portion of this, because so much of what I'm going to talk about directly correlates and piggybacks kind of off of what he had talked about. And one of those is drafting real estate profit distribution provisions, which is essential and absolutely critical when drafting an operating agreement in the real estate arena. The reason why this is so is because many of the disputes that you would find yourself in on the back end come from people's disagreements with how distributions are ultimately given out and different expectations. So if you can draft a provision that's concise, clear, and meeting all of the client's goals, you can absolutely prevent yourself from getting into those kind of situations. The first thing that we wanted to look at are whether you want to do periodic payments or lump sum distributions. And going back to what Ross was talking about with a manager managed LLC or a member managed LLC, that will likely dictate whether you would want to do a periodic or a lump sum distribution. For smaller LLCs, more think about family owned, small 2-3 party LLC agreements, lump sum is probably not the right way to go. A periodic, let's say two people own, like Ross's example, the brownstone apartment. If you own a brownstone and you're renting it and you bring in one partner, you are more than likely trying to use portions of the income of the rent to supplement your income. That would mean that a periodic payment that you can depend on would be the best way to go. It works well when it works well because you can set up a monthly structure, a quarterly structure, an annual structure, and if there's a steady income from the rental property that someone can depend on for their income, periodic distributions are perfect. Again, you need to make sure that both parties are in agreement, or the small group of parties are in agreement to do the periodic payments. You can also avoid tax spikes by doing this, because the tax impact on investors is lower, and they can know what to expect when they're getting more frequent distributions. You can also have better cash flow management if you're going to do this. You know what's coming in on a monthly basis, and you know what's going out. The cons of doing the periodic payments are that there's obviously fluctuations in the market. If rentals go down, if you're in the brownstone and you don't have that floor rented, your cash flow is going to be down that month. You're not going to have maybe the distribution that time. There's also more administration costs because you have to have somebody accounting for it on a more regular basis and doing the distributions. There's also less capital available for investments. You are using the capital from the LLC on a more regular basis as an outflow. However, if it is a smaller held LLC, it's a very good option for people that are using distributions from the LLC as part of their income. A lump sum payment, on the other hand, is great for bigger LLCs, more investment type risk-taking scenarios. There's a higher immediate return, so you get a substantial payment at once, and again, make sure it's agreed upon, but the LLC members can decide whether to reinvest that payment to make another investment or to take it. There's also reduced administration costs because there's not the consistent accounting or the management costs involved. For tax purposes, investors can strategize what their tax obligations are going to be based on what the annual draw or distribution would be instead of the fluctuating month to month or tri-annually. If an LLC generates returns primarily from property sales, a lump sum distribution makes sense. If it's an LLC that is very investment oriented, a lump sum makes sense. The cons are that the members cannot be expecting a steady monthly income, so to say, from a distribution. There has to be a triggering event and a sale at the annual time, a refinancing. There's no regular income stream, and everyone needs to be well aware of that when those provisions are drafted. Also, a large distribution in 1 year can push an investor into a higher tax bracket, making tax liabilities more for a year where there is a big distribution. There's also that risk factor for clients where if you're depending on a lump sum payment and you're depending on a triggering event to have that happen, how's the market doing? How are we going to get this next investment? Are we going to be able to refinance? What do our opportunities look like? Which are all things that you should probably discuss with the clients when figuring out whether to do a lump sum or a periodic. The other main issue with distribution provisions that we have seen cause conflict on the back end are exactly how those distributions are made. What are we calculating? What are the funds that are going to the people? How are we distributing them? And people disagree on this. Some members might want to only use gross profits. Some members want part of those gross profits to be reinvested and put back into the LLC. So it's important upon the distribution to expressly provide what income streams are going to be used as the distributions. Typically, it is gross revenue, which in the real estate sense is gross revenue minus equals operating expenses, profit that you get from your income, rental, reinvesting, minus your operating expenses, minus your debt. So you need to look at what do these clients have debt-wise? What's their debt to net ratio? What are their monthly income and going income revenue stream and outgoing sources that they have to pay. Also operating expenses, which most people think about, but when they are looking at the investment and deciding whether to actually make a capital contribution, they might not fully consider. And these are operating expenses, which are things like if it's an apartment building, property management fees, maintaining the parking lot, maintaining property taxes, utilities, if that's paid for by the owner. And those have to be considered into the gross income and what can be distributed as income. Obviously, higher operating expenses reduce the amount of gross revenue that is then available to be distributed. Debt services is another issue that most smaller investors might not be truly considering, which is how is the mortgage going to be obtained? How is it going to be paid? How are the interest rates? How does it look in 5 years? Again, we are not tax attorneys. I'm not a tax advisor, but those are considerations that every client should consider when they're before we draft a profit distribution provision. The ultimate goal when you're drafting a profit distribution provision is to balance flexibility. Again, what are the client goals? Are they small? Are they a closely held LLC, few members, or is it a large? Are they risk adverse? Are they investing and in growth mode? And try to take those goals and provide the structure and precise language and defining exactly what revenue we're using, what distributions are going to be made to give them flexibility to meet those goals. Again, you always want to use plain language, but also, as Ross was saying earlier, you need to use shall. Distributions shall be made on these parameters. You want to obviously lay out what the voting rights are and dispute resolution, which we'll talk about in a moment. And there's always the need at the front end to look again at the back end and see what are your future developments going to be. When is this LLC going to look at refinancing? Is this a short-term investment for people? Is it a long-term investment? Are they planning on asset sales in the near future? And what are the dissolution scenarios that they might face? So to reiterate, when we want to draft proactively to avoid disputes, which should always be the goal, we should always be trying to meet our clients' goals proactively in a flexible yet structured way so that we are not ending up in a dispute between the parties. So first of all, you need to identify all the parties involved. Who has the stake in the distributions? And with a real estate LLC, it is usually people who make the capital contributions, if there's a managing member, if there are investors, developers, or property owners, which can be silent partners. There can also be other LLCs. And there can be different classes of members with varying distribution priorities, meaning that, which we will talk about in a few moments, like varying distribution priorities, meaning varying levels of whom gets what distribution at what time. It's also very important on the front end to clarify what the ownership percentages are. If certain people are founding members of the LLC, they can have a higher percentage. They can get a higher distribution rate. Is it going to be a direct proportional allocation, meaning everyone gets the same, or it's directly proportionate to what your capital contribution was, or is it going to be customized, which we'll talk about with the waterfall scenario? There's also different distribution priorities, as we talked about. Usually, whomever makes the capital contributions are paid out first, and then in most real estate LLCs, the private priority investors are paid second at usually a 6 to 10% priority, and then a general manager is paid last. When we're drafting to proactively avoid disputes, it's obviously important, as we've discussed, to define your revenue streams. Where is the money coming in? What do you have to depend on? Rental income, again, this is important if you're doing periodic lump and not lump sum payments. What's the rent coming in? What income do we have to be distributed? What's the history of that? And what does the market look like moving forward? If it's a lump sum payment, what are our sale proceeds going to be? What does the market look like? What is our next opportunity? And then to weigh out the tax benefits of both. Most LLCs will define, and I would suggest doing this is defining what gross profits is in the operating agreement, which we went over, so that everyone's on the same page and knows exactly what the pot is that's going to be distributed. If you're going to do periodic distributions, you also have the option of when are the distributions going to be made? What's your period? You can do monthly, we could do quarterly, we could do semi-annual, and that again goes back to who is your client? What does the LLC look like? Is it very small? Is it a few people? Is it large? What do people expect? Monthly distributions are great for stable rental income properties, such as multifamily or some commercial leases. It provides a steady cash inflow, and it makes it ideal for people that are seeking income, and if your clients need immediate investors. This also creates a predictable financial rhythm for the LLC. You know what's going in, you know what's going out. The quarterly distributions, which would be every 3 months, is great for mixed use properties. Think of office buildings, commercial real estate, or some sort of business that has a periodic rent collection. So you're not so sure that a monthly income is going to be coming in, but they have a month to make it up or they're in default. Balances, you have consistent investor payouts, but you also can maintain more of an operational cash flow for the LLC because you're not having to monitor it, less management every month. It also allows time for rent collection and expense management before the profits are distributed. Semi-annual distributions, which would be every 6 months, are great for development projects, value-added properties. You buy a depreciated asset, you buy a depleted building, you're going to do the renovations, the investments there, you're going to do something mixed use, then you look forward in 6 months and think that the asset is going to appreciate. That's great. You can handle the vacancies, you can stabilize cash flow. It gives you time to create those profits. It also reduces administrative costs further than quarterly or monthly payments. So the semi-annual is really good for investments that require a substantial investment with time before you're going to be actually generating stable income. Less frequent payouts are obviously could be unattractive to some clients that need a steady cash flow or depending upon a monthly distribution as part of personal income. You also need to do longer financial planning to assure that what the market looks like in 6 months and how these profits are going to be generated. Annual distributions once a year are great for opportunistic investments, people that are okay high risk with high risk, opportunistic, vacation rentals, buying land, development projects that have yet to be started. It is clients that are okay with making an investment and waiting on a return. It allows a full year of financial evaluation before the LLC has to assess and make any type of distribution. It also helps to retain cash reserves for a period of time before before the funds are depleted. And it's great for reinvestment needs. You have a pot to go to if there's another investment project. It's ideal with investors with a long-term wealth building mindset. Obviously, this is not a great option for, again, people who are looking for the LLC distribution as part of personal income. So we're continuing on how to draft proactively to avoid disputes. That's always the main goal. As Ross was saying earlier, LLCs are such a fantastic way to be able to structure something for your client that anticipates future problems and can work proactively to avoid them. So according to when we are applying this to profit allocation, we want to make sure when we are drafting these provisions that everyone that is involved knows exactly what the proportional distribution is, if it's based on ownership, if there are preferred returns, meaning some people are going to get paid out before others, or if there are fixed returns before that there are any profit sharing for the general members. So that brings us to talking about what a waterfall provision is, which is a great option for real estate operating agreements. This is a scenario where there's a class of investors that make a capital contribution, and then an investor that is putting in sweat equity and doing the management or the day-to-day work for the LLC. So in a waterfall scenario, when a distribution is made, first of all, everyone gets their capital contributions returned. Second, the preferred investors, the people that actually put in the money and that are not the general managers, get the first 8% above that. And then the general manager, it's usually a 30 to 70 split, gets the distribution next. And that's a great way for people that don't want to be involved in the management or day-to-day process, such as a managed LLC, but they would like to make an investment. They don't want to have any liability. They do not want to have day-to-day decision-making problems or powers with the project. They can put in the money. They get paid absolutely first on a preferred basis after the capital contributions are paid out. And it allows people that are wanting to invest but don't have maybe the capital to do it, but then they have the know-how, the people that actually run the restaurant or manage the apartment building. They're the sweat equity. They get paid third, but they're still in line to get a distribution. So the waterfall works very well in that scenario. Waterfall would not be probably the best solution for what we were talking about earlier with a small LLC, a family member, a two-person in that aspect. It would be much simpler just to do every member gets the distribution payout, same schedule, same percentage. Again, it's something that you want to address with the client on the front end, see what the needs, goals are, and how best to meet those. The other thing about distributions that I think is very important, and it's something that Ross had touched on earlier, is the fact that we need to be aware when we are drafting distribution provisions, how exactly people are going to use those distributions. You can build in provisions in the LLC agreement saying that part of the distributions are going to be put into a reserve to make future investments, put into the operating costs to grow the investment. And we want to make sure that members are on the same page with how distributions are going to be made and what is going to be done with that money so that there are not disagreements as to how the LLC is being managed. We touched on this a little bit briefly earlier, but you definitely want to proactively define what revenue streams are going to be used for profit distributions. Rental income, sale proceeds, what are the tax costs and benefits of each? And your clients need to be aware of how things are going to affect their tax bracket if you're on that periodic instead of a lump sum, or both a periodic and a lump sum payment distribution schedule, what the tax benefits and potential downfalls are. And we talked about how to define gross profits so that everyone in the LLC knows exactly what money is coming in, how we're defining it, and how it's going out. We talked about this. This is just a recap of proportional distribution, which would be based on ownership percentage or capital contributions, which I've mentioned is best for a smaller, closely held LLC where there's just a few owners, and then the waterfall structure that is great for bigger projects, multi-member LLCs that have a general manager, excuse me. As Ross mentioned earlier, a reinvestment clause can be very useful and very beneficial. You can build it. The great thing about drafting these operating agreements is that you are able to creatively problem solve and figure out strategies that clients want to do. If they want a reinvestment clause where some of the available distribution profits are going back into reinvestment into the LLC, we can build a provision in for that, which is a great strategy for helping clients meet the goals they have for reinvesting, growing the LLC, and making and avoiding tax tax implications as well. When we're drafting to proactively avoid disputes, we want to consider federal and state tax implications. And one important aspect of that, which is an interesting and great way to utilize the Internal Revenue Code, is to reinvest as a 1031 exchange. And if you're using a 1031 exchange, this allows investors, when a property is sold, to reinvest all the proceeds from that sale of a property into a like type property, meaning if it's commercial, it needs to be a commercial. You cannot sell a commercial and put 100% of the proceeds into a residential or a personal home. But if you do that, it allows you to avoid any capital gains taxes on the sale of the first property. There is a 45-day identification rule, which means that the replacement property must be identified and under contract within 45 days. And then it must be fully purchased within 180 days of the sale of the first property. Again, in the funds held in escrow from the sale of the first property cannot be given to the seller until the second property has closed. But again, it's a great mechanism for clients to avoid paying capital gains taxes on the sale of one piece of real estate. These are examples of a company balance sheet that I think can be useful to have. It shows a typical balance sheet and how gross revenues are calculated. And we went through that, so I don't think we need to do that. And we've talked about maximizing personal asset protection through an LLC. An LLC is a great mechanism in an ability for a client to maintain anonymity, avoid taxes, liability, not only as an individual, but we've actually had an interesting case where a client used a trust, set up a trust, and the trust became the member and the contributing capital contributor to a real estate LLC. And when the real estate LLC got sued, it was the trust who got named. It could not be the individual that was the trust, the founder of the trust. So that's a great, using an LLC as a double layer for you or for your client can be excellent. As Ross was saying, you can have even a double layer. Have the managing LLC with smaller LLCs underneath it, and then the individuals underneath that second layer. We actually also have a very interesting case involving real estate entities in New York, restaurant entities, and one of the central core issues in that matter is the managing member who's being sued for breach of fiduciary duty and other corporate mistransactions and fraudulent behavior is being shielded because it's very hard to pierce the corporate veil when there are two levels. We have the managing member, and then we have the individual who is its own LLC, who is the managing member of the manager, and then we have the individual. So there's two layers. Again, that can be useful to protect the individual, and it's especially under New York business law, it's very hard to pierce that corporate veil to get to the individual when there's multi-layers. So it's a strategy that's very applicable, especially in the real estate world. We've talked about proportional versus waterfall distribution and the reinvestment versus payouts. Again, these ideas all come back to what is your client's goal, what is the goal of the LLC, and how are they trying to meet those goals. The tax implications, as we've said, are pass-through taxation affects members' personal tax returns, although I explained how a lot of LLCs use the Section 1031 to avoid that if there's going to be reinvestment, which is a great option. This goes through a little bit of the tax treatment for real estate LLCs, depending on how many members there are and what classification you've elected as your LLC. As a single member, it will be taxed as a sole proprietorship, and you report it on a Schedule C. A multi-member, you're taxed as a partnership, and you need to make sure that everyone is getting a 1065 and a K1S form. We've also had cases where the LLC was found to not be valid because members were not given the K1S forms and were not following formal procedures. If you have an S Corp election, you can reduce self-employment taxes for active real estate professionals. And then there's the C Corp, which is a double taxation, so it's really not recommended for an LLC because it would be taxed twice. One thing that I would like to highlight is the fact that if you are having an LLC with a manager or employees, such as an apartment manager, property manager, any employment taxes and employment classifications need to be absolutely vetted and classified appropriately through the LLC, because anything employment tax-wise or employment classification-wise, an individual, it will automatically pierce the LLC veil, and an individual can be liable for the recovery of those taxes as well as the LLC. So that's very important to consider when you're structuring tax or when you're structuring employment provisions and hiring management or employees as to the LLC. Again, there's more tax information that's contained on these slides, and we would advise you to go over them and talk to a tax professional, probably a CPA or a tax attorney as well.
Okay, well, I did see there was one question, which I can read out, and thank you for that, Sarah. The question is, does a manager-managed LLC provide additional liability protection? So I can answer that as follows. There's no further limited liability protection if it's manager-managed versus member-managed. Generally speaking, members just simply are not personally liable for business debts or lawsuits or obligations beyond their investments to the company. But there is a benefit with the manager-managed structure, and that is that, number one, you'll find that non-managing members can't bind the LLC or make business decisions when there's a very clear delineated manager for the LLC. So in other words, if you're member managed, the members can all do things that can bind the company. And then what can happen is that if there's a lawsuit or if there's potential liability, anybody can kind of potentially be exposed, because if it's member managed, any member has that authority, the signatory authority, the agency to bind the company. When you're manager managed, that's outsourced. That's pushed out to whoever is the managing member, whether it's a third-party management company or the managing member. So through that lens, there is this shield or kind of distinction where if you're a passive investor as a member, you no longer really have to worry about these issues of whether or not I could potentially be considered to have involved myself in an unauthorized act. So when there's a lawsuit, they're going to be looking directly to the managing member as the participant that had the signatory authority. So in a way, even though the limited liability doesn't change, having that outsourced manager does provide a certain benefit. And then it kind of proceeds from there. If you have a management-based company, it reduces internal disputes and potential liability from unclear authority. Well, whose right is it to do what? Could this manager have done this, or this member should have done that? We know that that's the manager who's responsible for these things. And so again, when you're dealing with the passive members who aren't involved in the management, it likely can reduce their risk of being held liable for certain management decisions that it's very clear they would never have been a part of in the first place. And the benefit beyond that is the external clarity that that provides. So there's this idea that when we're dealing with third parties, the management company is the one that's going to be speaking and representing on behalf of the LLC. They're the ones with the signatory authority. It just reduces the potential issues of getting wrapped up in something. So while the ultimate liability is the same, it's a great question. The manager-managed LLCs can provide a little bit more of distinction between who could be responsible for what, but ultimately members and managers, the limited liability structure still remains in place. I hope that's clear.
We had another question from a client, Ross, that asked me, do you recommend putting in your LLC agreements requiring a supermajority or just a majority vote, or do you think that there's a difference or a pro and con to either?
I think it's a great question, and it really depends on the structure of your company. So if we're dealing with two members that own an LLC together, obviously the whole issue of majority versus supermajority, if they're both 50-50 members, not going to make a material difference. In fact, 50-50, they're at heads, they're butting heads, and they're butting heads. There's nothing you can do. If you're dealing with a bigger company and there's multiple different members, I would say that for material alterations, which are of significance, most likely you're going to want a supermajority provision in the ultimate agreement. But this is a dialogue to have amongst the members and to sort of weigh the benefits and the detriments and to look through the pros and cons. Generally speaking, though, for things such as the sale of the real estate itself, things like refinancing, I mean, those are pretty large decisions that impact the LLC and the members themselves. So when it's really material, the supermajority tends to be a way to go. That's usually considered to be pretty robust and beneficial.
That's what I would say. And I have had another question, and I think it probably you would agree to. It depends on the situation, but what's your feeling on putting in a choice of law provision on the operating agreements?
Well, that is a great question, and I think when dealing with choice of law, it's especially if the property is located in New York, it would make sense to have New York law govern. So most of the time, I mean, in all of our agreements, we always recommend choice of law provisions. There is really never a scenario where we wouldn't want to see it. But when we're dealing with New York-oriented real estate, we're certainly going to want to have New York law governing those disputes. And 9 times out of 10, the choice of law and the forum for disputes, in other words, a specific venue. So if we say, for example, New York law shall govern all disputes, we then discuss the venue, which is really 9 times out of 10, the county in which the property is located. But we have seen scenarios where, for example, you'll have let's keep it really simple, but two members of an LLC, they each reside in Queens, but the property's in Kings County in Brooklyn. And ultimately, the venue will generally be in Brooklyn unless at the time of drafting, we specifically outline a venue clause indicating that venue shall stay or obtain in Queens County. So these are, sort of nuanced scenarios that we always want to kind of consider and discuss when drafting, but they're changeable on a case-by-case basis.
Well, and I think it's a great option too, if you are putting in an arbitration clause, to think about, even though there is an arbitration clause stating New York law will apply. So that you have that option if your client needs that. There is another question. What role does proper record keeping and adherence to corporate formalities play in maintaining the LLC's protective benefits?
So that's a really good question. And it becomes interesting because, the BCL, under the BCL, which is a much older statute than the New York Limited Liability Company Law, if you're not maintaining corporate formalities, you could lose that corporate protection that you get. So the shield you get from the structure can actually be fully lost. Now, the LLC is a little bit different. You don't have to actually maintain the high level of standards simply because the LLC doesn't have the same amount of requirements. However, you do at the very least need to maintain sort of basic standards that is set forth in your operating agreement. So if you, for example, are commingling funds or engaging in financial scenarios that are debilitating to the LLC itself, or you're using funds that don't belong to the LLC but putting it into the operating account of the company, that's going to start to cause major and significant issues. But if you're simply concerned because, well, we haven't held a quarterly LLC meeting or an annual LLC meeting, that's not required necessarily. And because of that, you don't have to worry as much concerning corporate formalities. What really it comes down to is if there's mismanagement of an LLC, that's a problem. Now, if the mismanagement is simply negligent, you're likely not going to lose your corporate shield. But if it's reckless, if it goes above and beyond the standard of reasonableness, and if we're looking at intentional conversion of assets or fraudulent conduct, then we're likely to have a problem. I mean, if we're in a scenario where you have a member of a company that winds up taking the escrow account with tenant funds and transfers them to another account altogether, purportedly for this individual's own benefit, not only are you going to have litigation against the company and this member specifically individually, that member is going to lose any potential protection that he or she had from the law because the corporate veil will be pierced. And beyond that, there's going to be an emergency application that should be brought that will attach the bank account in which the funds were transferred, and there will be a whole rigmarole of sanction-oriented conduct that the courts can initiate against somebody for that type of bad faith conduct. So while it's not as rigorous, the LLC structure, it really comes down to the reasonableness of the conduct and whether we're dealing with simple negligent conduct versus reckless or intentional conduct.
Yes.
So Sarah, I see one here that says, how can business owners assess whether forming an LLC is the best strategy for protecting their personal assets given their unique financial situation and risk profile? Any ideas on that?
Well, I think that, we've discussed a lot today, especially in your portion in the beginning, that an LLC is a fantastic, vehicle for protecting your personal assets because it gives you a layer of protection and anonymity and a layer between yourself and the public, as long as the formalities are followed and the LLC is operating according to its operating agreement. An individual is protected as a member of the LLC for the actions taken by the LLC. So it's a way for an individual to act with a layer of protection from litigation and suits against them. That's what I would say. What would you say?
No, I completely agree. And I mean, even if you're looking at a sole proprietor who's operating, there is no cohesive scenario from a legal perspective, and really highly likely not from a tax perspective either, where it wouldn't make sense to at least have a single member LLC that protects the owner from that individual liability just in case something goes wrong. We used a slip and fall, trip and fall scenario in an earlier situation. Somebody gets harmed or there's some sort of contractual breach that really wasn't in bad faith, but things just didn't work out, or the individual business owner is having financial struggles. Can you imagine a scenario where they're not protected? If there's a judgment that's issued against that individual owner, if they're a sole proprietor, you can go after their bank accounts. I mean, how many information subpoenas do we send out as a law firm?
Absolutely.
for information where we start to attach bank accounts and claw out funds. So being able to avoid that scenario is instrumental. And that's for an individual. If you have multiple individuals, I mean, right, what's a partnership? A partnership is two or more individuals carrying on business for profit. When one of the partners leaves the partnership, the whole partnership structure falls apart. There's essentially dissolution. That's what made the corporate structure so fascinating, was that it survived and outlived the lifetime of the individuals that encompassed it. So now you have the LLC structure coming into place, simplifying the corporate structure and allowing for a continuation in the right circumstances where the LLC can survive. So even when you have multiple owners of an LLC, not only will they want to shield liability, you then shift over to protecting personal assets or unique financial scenarios and risk. Well, protecting personal assets, you need an entity. If you don't have it, you're not protecting your personal assets. So that's why you absolutely need a protective structure around you. And then discussing unique financial situations and risk profiles, that would be more aligned with, number one, the terms and conditions and details of the operating agreements, but also tax considerations. And that's where you shift over to the tax strategist and the CPA and the tax attorney that will focus on, does it make sense to elect the LLC as an S Corp, or would it make sense to file as a C Corp? Now, we've been dealing with businesses that are smaller, and when we say smaller, we might mean under $10 million, where the S Corp structure is beneficial because you avoid the double taxation. But as you get larger, and as businesses especially enter well into the 8 figures, 9 figures, they're talking about IPOing, it's a whole different ballgame. And that's where the corporate tax structure, the C Corp structure, could be the beneficial means of which to implement for taxation. One big question that we always get, or kind of distinction that seems nebulous for people, is that they'll say, well, I want to set up an S Corp. And we'll say, well, what do you mean you want to set up an S Corp? An S Corp is a tax filing election. You don't file an S Corp as your ultimate entity. You can file an LLC, register an LLC, and then elect to be taxed as an S Corp. So I think those are the things that we find that can certainly be ameliorated by having LLCs and by having structures around you and by having the right people advising you and guiding you in these types of scenarios. Sarah, I don't know if you could speak to, but I know there was something about, and I see the question was there about management agreements. So having the LLC when they do outsource management of real property, are there certain flags that you happen to see in those agreements, things to look for when an LLC outsources management to a management company, just from a contractual basis?
I think from a contractual basis, you need to make sure that obviously your basic provisions are there. The management company knows exactly what percentage they're getting paid. Where are the funds coming from on your end? You need to be prepared for that. And I would say that the management company needs to be vetted, and somehow a lot of times when people use an outsourced management company, there's not someone on the ground that's making sure that things are done. So I would get indemnification from the management company for something that's happened on the management company's watch, so to say.
And does that tie in a lot to insurance, would you say, having proper insurance in place from the perspective of management?
Absolutely. I think that in addition to having premises insurance and general insurance, that having some sort of an insurance or having the management company covered by you would be beneficial. Especially again, if it's a scenario where the management company's doing something that you aren't, the LLC or a member doesn't have eyes on and is very hands off.
No, I think that makes a lot of sense. I see another question here. How can attorneys incorporate succession planning and estate planning considerations into a real estate LLC operating agreement to ensure smooth ownership transitions? So that's a really good question. So there's a number of different provisions that we tend to see in these operating agreements, and sometimes they overlap with others. It can get really convoluted, but basically you can have death or incapacitation provisions that basically state at the time of death or incapacitation of a member, incapacitation to be defined, there are specific details that outline what is going to happen in that situation. And so one example could be there is a mandatory buyout where the other members have to buy out the shares that will now transfer or pass to the estate of the decedent. There could be, so that's one way, and that's a benefit that the family of the decedent would get, or the incapacitated member, when they're now able to, they lose out on the ownership, but they're going to get some sort of financial payout, which should ultimately benefit the family. Another scenario could be that upon the death or incapacitation of the member, there is an assignment to the member's heirs. And in that situation, you could have the member's death or incapacitation results in, let's say, a spouse, a wife, or even adult children taking the stead of the member that's now incapacitated or deceased. In that situation, sometimes there are problems that arise, especially if the decedent member was an active participant in the company. When that's the situation, you usually want to have a clause in place to ensure that when a family member takes over, they are now a passive member of the company. They're not going to be involved in the day-to-day of the business. And I say that because we've seen scenarios where a spouse or an adult child has wanted to get involved, and it's led to so much headache and problems with the other members that it's best for them to convert into a passive owner in the company. Now, as you can imagine, whether or not there's going to be a buy-sell agreement upon death, or if there's going to be an assignment to the heirs, it really is a conversation to have with the member that's coming into the company and what they ultimately wish to accomplish. And then, of course, this needs to be clarified and confirmed with the other members. So that way you can either have a blanket provision for all members of the business, or there can be a distinction where certain members are actually laid out in the operating agreement. You know, member X, this is what happens on a trigger of death or incapacitation, and member Y, this is what happens with their membership or equity ownership upon death or incapacitation. And I would say too, when you're dealing with the buy or sell scenario, a mandatory buyout, there always needs to be a valuation provision that makes it abundantly clear, number one, that there's going to be a third party independent valuation, usually to be paid for by the company. An appraisal is going to be discussed. You should have a formula set forth in the operating agreement that's going to talk about how you can properly appraise the value of the business. There should be, of course, a CPA review. And then payment terms. Is this going to be a lump sum buyout? Is it going to be a buyout that's made in installments, so over a period of time? These things are really important. So these are the types of scenarios that you're going to want to consider, especially when dealing with incapacitation or succession planning. And the other issue beyond death and incapacitation is retirement. What if somebody truly wants to retire? Does a retirement or a resignation automatically implement a trigger for a buyout? If so, what type of notice needs to be given? Is there a true right of first refusal, or can somebody who wishes to retire simply find a third-party buyer and sell to them? If they do, if a member sells to a third party that wasn't previously a member of the LLC, well, are they going to be a passive member? Is there a restriction in the operating agreement that states that any new members that come into the company ultimately will be passive and not active? Maybe they have voting rights, but they have no management rights, and that can't change, or it can only change by a majority vote of the members. So as you can imagine, there's many, many different scenarios that can come into being. So when we consider these types of agreements, it's never something that's done rapidly with just a quick provision. It requires a full conversation, full vetting, looking out for the individual client to make sure their best interests are being considered, and then preparing and drafting from there.
And I think it's also important what you touched upon to absolutely determine and put in there a right to have an evaluation and how that valuation is going to be done. Because we've seen this scenario where trying to get an evaluation, prove the right to have a valuation done and how that's going to proceed.
Right, and we've also seen scenarios where each member has their own valuation, and then there's a third-party valuator to look at the two valuations and the appraisals and ultimately make a final conclusion as to what the value of the appraisal of the property would be and the valuation of the equity interest would be. So to your
Which is an
point,
expensive endeavor.
it can get very expensive. Yes. No, I think that's very, very true. So always things to be mindful of when drafting these agreements.
I think it's, but yes, be proactive, think what's the back end going to look like and what are the client's goals and ultimately how they can get there.
Sure. I think that makes a lot of sense. Okay. How can capital contribution provisions be structured to address potential future funding needs and avoid disputes among members? That's a great question. It's also a very loaded question. I think the key is that at the very onset of the investment, the capital contribution structure needs to be broken down right away. And it needs to be discussed how and when capital is going to be returned. It needs to be discussed if it's going to be returned within a specific period of time, or if there are certain trigger events from a financial perspective that are going to allow for that return. And then there needs to be a conversation about capital calls and what they're going to look like and how it is that they're going to be implemented. If you can cover those two sides of the structure of contributions and capital calls and the best means of ensuring that everybody has a full understanding of what it means when they put funds into the company, that sets forth the best and greatest plan to avoid malfunction and ultimately disputes moving forward in the future. Not something that's easily obtained, but certainly something that is very feasible to piece together in a way that's most likely to avoid disputes in the future. Okay, I think we've answered all the questions, so that's it from us. So I'd like to thank everybody for spending time today and listening to us speak about real estate operating agreements.
As stated during the beginning of this presentation, the link to initiate the certificate process will be displayed momentarily. My Law CLE would like to thank you for your participation in today's presentation.